Hey guys, it's Matt LaRosiere here with Firearms Policy Coalition, bringing you another weekly update, just to make sure you have all the latest information on everything affecting your right to keep and bear arms. First up this week, Barrett passes committee. We have news on Judge Amy Coney Barrett's nomination process. On Wednesday, the Senate Judiciary Committee voted unanimously to advance Judge Barrett's nomination. If you're wondering why it was unanimous, that's because the anti-gun and politically opposed legislatures all walked out in protest. Real mature. In any case, Judge Barrett's full Senate confirmation vote is scheduled for Monday. Next up, Wyoming to dox gun donors. In Wyoming, State Secretary of State Ed Buchanan has announced that he's ordering Wyoming gun owners, a long-established gun rights group, to hand over the names of its donors by November 4th under penalty of fine. The reason for their order was a formal complaint against the gun rights group claiming that they had violated state campaign finance laws. The basis? Well, they're claiming that it was engaging in electioneering, which caused the failure of some anti-gun political candidates. That's an interesting position when you consider that people probably voted against them because they didn't want their rights taken away. Anyway, circumstances of this particular situation aside, it does raise an important issue about the ability of nonprofit civil rights organizations to decry politicians who would deny people their rights. Next up, CDC dollars at work. This week we have more federal waste thanks for the Center for Disease Control, who's given a grant of $250,000 to University of Connecticut researcher who is investigating, wait for it, cyberbanging. Anyway, the purpose of the research is to aid in preventing gun violence. At least that's what's being claimed. We all know what the real reason is. It's to use taxpayer dollars to fund research that will be used to restrict gun rights, likely through a form of government surveillance. I don't know about you, but I've had my full of domestic surveillance programs and Big Brother. Next up, young Pennsylvanians challenging gun laws. In the Commonwealth of Pennsylvania, we're currently helping young adults sue the government over gun rights discrimination. The issue is that during public emergencies, the only people allowed to carry firearms, apart from government agents, are individuals who possess a license to carry. The obvious problem with this requirement is that the licenses are only issued to people 21 or older, which means that legal adults aren't able to defend themselves because of some arbitrary limit. We know it's arbitrary. After all, they let 17-year-olds stand armed watch in the military, so they can't really argue that it's an issue of age. Next up, rights denied to tape smuggler. This week, the 11th Circuit denied a petitioner's request to have his gun rights restored after he was convicted over 33 years ago for a smuggling charge. What was he smuggling? Counterfeit cassette tapes. For those of you who are too young to know what those are, they're an old music format that people used to play in stereos and in their cars. They also used to hold computer software on them. It's complicated. Anyway, the decision is horrendous for two reasons. First, from a public policy perspective, the founders never intended to prevent people from bearing arms based on a conviction for a nonviolent crime. After all, the point of allowing the government to disarm individuals was to stop people who were demonstrably violent and had been proven to be so. Second, from a statutory perspective, the conclusion is just wrong. Copyright laws and anti-smuggling statutes, as applied here, would constitute restraints on trade and the regulation of business practice. Conviction for violations of either shouldn't be disabling under federal law. These are supposed to be civil things. But anyway, while we're on the topic of bad legal takes, Second Circuit's slaps community property. The Second Circuit also announced on Wednesday that a woman seeking to have her firearms returned based on her husband's conviction had no right to have them returned under the Fourth Amendment. According to the court, the government's unlawful retention of her property was too novel a theory to warrant Fourth Amendment protection. I didn't know it had to be a new abuse to get protection. Gun rights aside, this ruling is massively problematic because the court is looking the other way on the state taking someone's lawfully but jointly owned property because the other owner may have broken the law. Last up this week, Virginia update. In a surprise move by the Virginia legislature, Northam's anti-gun gang has dealt its law enforcement a blow in the fight to prevent the rightful possession of firearms by Virginians. Virginia Senate Bill 5029, which passed recently, protects drivers from unreasonable vehicle searches. This is pretty cool. Specifically, the cops can't conduct warrantless vehicle searches based on probable cause for things like detecting the owner of marijuana, broken taillights, loud exhausts, and window tint. This means that the police can't use those things as a pretext for searching your vehicle when they see a SIG, Glock, or more preferred, an FPC sticker on your back window when they pull you over. Well, that's all I've got for you this week. Thanks for tuning in. If you'd like to know more, check out fpcnews.org, where you can find this week's edition and information on all of our legal and legislative efforts. Also, be sure to check out fpcgear.com, where you can get all kinds of cool Pro 2A gear and help keep us in the fight in the process. As always, keep your eyes on Firearms Policy Coalition, where we're keeping up the fight for all your rights all the time. I've been Matt LaRosiere, and I'll see you real soon.